हेलो ऑल एंड वेलकम टू रैंडम थॉट्स विद अनिकेत बर्वे। आज डिस्कस करेंगे इनकम टैक्स एक्ट का बहुत ही इंटरेस्टिंग सेक्शन विच इज़ 1026 ट्रिपल ए, जो डील करता है विथ इनकम टैक्स एग्जेम्पशंस टू द पीपल ऑफ द स्टेट सिक्किम। In 1600s, Sikkim was being ably governed by the indigenous kings until the British took over. In 1861, the British signed a fresh treaty with the King of Sikkim and handed him over the rule of Sikkim subject to certain conditions. उसमें से एक कंडीशन ये था कि द पीपल फ्रॉम द देन ब्रिटिश इंडिया विल बी अलाउड टू फ्रीली एंटर एंड इवन सेटल डाउन इन द टेरिटरी ऑफ सिक्किम. And few Indians did settle in the area of Sikkim, retaining their original Indian citizenship. Now in 1950, independent India signed a peace treaty with the state of Sikkim and undertook to be its protector. उस टाइम एक रेगुलेशन निकाला गया विच वॉज नोन एज सिक्किम सब्जेक्ट्स रेगुलेशन 1961. एज पर दिस रेगुलेशन, अगर आपको सिक्किम सब्जेक्ट बनना है एंड यू आर नॉट ओरिजिनली फ्रॉम दिस लैंड, यू हैव टू गिव अप द सिटीजनशिप फ्रॉम वेयर यू केम एंड देन ओनली यू विल बी कैटेगराइज्ड एज अ सिक्किम सब्जेक्ट. So original Sikkim residents had no problem with being Sikkim subjects, but during the British rule, जो Indians migrate हुए थे retaining their Indian citizenship, some of the families did not give up their Indian citizenship and therefore they were not registered as Sikkim subjects. To put it in numbers, 95% of the total population was Sikkim subjects and 5% were these unfortunate migrants from the British India. 1975 में सिक्किम स्टेट became a full-fledged part of India and Home Ministry declared that all Sikkim subjects are deemed to be Indian citizens. So दो theoretical categories बन गए. One is Sikkim subjects who are now Indian citizens and second is the migrants from India under the British rule who had their erstwhile Indian citizenship but were not Sikkim subjects as per the definition. So after this long history, let's come back to the section of Income Tax Act. So after independence, Indian Income Tax Act was also applied to the state of Sikkim, which introduced income tax exemption for Sikkimese individuals. Now to make matters worse, in 2008 there was another amendment which said that this benefit of income tax will only be available to those Sikkim subjects which were registered in 1961. Along with this, another bizarre amendment was introduced in the same year 2008 itself, which said that any Sikkimese woman, if she marries any non-Sikkimese individual, she will lose exemption under this section. So as a result, this 5% of population which were not Sikkim subjects even lost their income tax exemption. Section was challenged before the Supreme Court and the Supreme Court rightly struck down both these amendments as unconstitutional in nature. So it is held that distinguishing Indians from Sikkim subjects by definition is unconstitutional. Also restricting the exemption under the Income Tax Act to a woman who marries to a non-Sikkimese individual is also unfair in nature. So as usual, waiting for your thoughts in the comments. Namaste.